Hi there, welcome to the LA FOIP 101 webinar put on by the Office of the Saskatchewan Information and Privacy Commissioner. So what we're going to look at today is what is LA FOIP, what is a local authority, who is the head and how to designate a head, what types of records does LA FOIP apply to, access, privacy, the IPC, how other acts interplay with LA FOIP, and resources and where to go for help. So, what is LA FOIP? LA FOIP is the Local Authority Freedom of Information and Protection of Privacy Act. It is a piece of legislation that establishes citizens' rights to request access to information in the custody or control of a local authority and request a review from the Information and Privacy Commissioner if they are dissatisfied with the response from the local authority. LA FOIP also provides local authorities with guidelines for the protection of information in their custody or control.
LA FOIP covers local authorities, and you might be wondering what a local authority is. So a local authority is defined in subsection 2F of LA FOIP, and it covers a diverse group of public sector organizations. This can be universities and colleges, libraries, school boards, health regions, and their affiliates. But most importantly, it's you. It's municipalities such as cities, towns, villages, etc. It's a committee of a council of a municipality, and it can also be any board, commission, or other body that's appointed pursuant to the Cities Act, the Municipalities Act, or the Northern Municipalities Act. So it covers your organization, but there might be many people in your organization. So who has that ultimate authority? And that is what we call the head. So the head, like I say, has ultimate authority and responsibility for access and privacy decisions. The head is defined in subsection 2E of LA FOIP. And in the case of the municipality, it's the mayor or reeve or chairperson of the local advisory committee. In the case of other local authorities, it's usually the chairperson of the governing body of the local authority. A head can also delegate its authority to someone else, such as the administrator. That delegation can cover all of LA FOIP or only part. So, for example, the administrator might only have responsibility for the privacy side, but not the access side, or any such setup. It can contain any limitations, restrictions, conditions, or requirements, but the key is it must be in writing. You can see section 50 of LA FOIP for more information. And next, we might ask ourselves, what kind of records do LA FOIP apply to? And that would be all records in the possession or control of the local authority. That may be general information such as budget information, accounts, etc. And it can also be personal information. And we'll talk more about that later in the webinar. Possession means a physical possession plus a measure of control. And control is a bit more complicated, but it connotates authority. We have a guide called the IPC Guide to Exemptions, which we'll talk about more later, and that explains more about control. So you can look that up if you would like to.
Okay, so one of the biggest parts of LA FOIP is the access portion. So you may receive something called an access to information request. An access to information request is a request for information in the possession or control of a local authority from a citizen or company. In LA FOIP, to make an access request, an applicant must pay a $20 application fee. A request should be made in the prescribed form. However, a verbal or written request will suffice so long as the request contains the applicant's name, address, and means of contacting them, such as an email or phone number. It needs to include the name of the local authority of whom they are requesting the information, and the name of the record, if known, and a detailed description of what they're looking for, preferably with a specific date or time frame. Only requests made in writing can be reviewed by the commissioner. And it is important to keep in mind that who the applicant is, whether it be occupation or personal relationship with yourself, should not play a role in how you respond to a request. So processing requests. Once you have received the $20 application fee, you have 30 days to complete the request. The first step is to determine whether or not you have records applicable to the request. Once you've determined if you have records, you need to determine if the amount of records or the time to process calls for a fee estimate.
As of January 1st, 2018, any charge over $100, not including the $20 application fee, requires a fee estimate.
Guidelines for how to process an estimate are in the LA FOIP regulations and as well as on our website. If you do make a fee estimate, when you send that to the applicant, the 30-day clock stops until you receive payment from the applicant. Once you receive 50% of the fee, you may begin to process the request. This is also a good time of the process to narrow the scope of the request of the applicant in case they do not want such a large fee. Another step before actually processing the request is to determine if there are any third parties involved. If there are, and you intend to release the records, then you must contact the third party regarding the request so that they can make their representations to you or request a review from the commissioner. So now you can begin the process of the request, but your 30-day clock has run out. There's an option to extend the clock an additional 30 days. However, this must be done before the initial 30 days is up, and the applicant must be notified in writing. So now the actual processing of the request begins, determining if there are any exemptions that apply to the records. Exemptions are exceptions to access that allow a local authority to withhold certain information. Exemptions provide, like I said, the local authority with the ability to protect personal information, as well as sensitive information of third parties, solicitor client privilege, etc. And there are two types of exemptions, mandatory and discretionary. Mandatory exemptions include the wording ahead shall and include third-party information or records from other governments. Discretionary exemptions include the wording ahead may. You should use your discretion when deciding whether to apply this exemption or not. Examples include law enforcement investigations, documents of a local authority, economic and other interests, or solicitor and client privilege. Still not sure about exemptions? Well, the IPC has come up with a handy tool to help. The Guide to Exemptions lays out the tests that will help you to determine whether or not an exemption applies to a record. It will also assist you in defending your reasoning for withholding information should we receive a request for review. And this document is available on our website and is updated regularly. So once you have finished processing your access request, the last stage is the Section 7 response. This is the last piece. In it, you must include any exemptions applied and contact information for the IPC so that the applicant can request a review if they see fit.
So now we'll look at the other half of the legislation, and that's protection of privacy. So privacy is about protecting the personal information of others. We'll look at what is personal information. We'll look at the three things we do with personal information. That's collection, use, and disclosure. We'll talk about the need for accuracy the need for safeguards, and then what to do in the event of a breach. So personal information is defined in subsection 23(1) of FOIP, and it's a really big long list, but we say it's not an exhaustive list. So the people who drafted the legislation could not possibly think of everything that would constitute personal information. So a good rule of thumb when making that determination is to ask, one, is it about an identifiable individual? And two, is it personal in nature? So examples could include address, phone number, race, religion, age, birthday, etc., etc. The list goes on. So the first thing we do with personal information is being collected. Sections 24 and 25 of FOIP give you the rules about collecting personal information. Here are three major things you need to know. So you should only collect personal information if it's absolutely necessary for the purpose for which it's being collected. We have a privacy principle called need to know versus nice to know. If you ask yourself, do I really need to know this? And if the answer is no, it's just nice to know, you probably shouldn't collect it. Next, local authorities should only collect personal information directly from the individual. So for example, if you're trying to collect a debt and that person's trying to evade you and you want to track him down, you might ask other people where he is. But in general, probably you should collect it right from the individual. And finally, you should inform individuals why the personal information is being collected. So next is the use of personal information, and this is the rules for use is in section 27 of FOIP. And use refers to a reference or manipulation of personal information. Personal information should only be used for the purpose for which it was collected, or purposes for which it can also be disclosed that are listed in subsection 28(2) of FOIP. Finally is the disclosure of personal information, and the rules for this are found in sections 28 and 29 of FOIP and also in the regulations. So the difference between use and disclosure are this. So for example, you need to share personal information with your council, for example. That would be a use. However, if you needed to do that with, say, the ministry, that's outside your organization, and that would count as a disclosure. A local authority can only disclose personal information if they have the consent to do so of the individual, or in circumstances described in section 28 or 29. Section 26 of FOIP says you must use or disclose or collect only accurate information. The personal information needs to be accurate and complete as possible. So if you're going to use, say, a list of names that are 15 years old, you should probably do some work and make sure they're all up to date. So how do we protect personal information from being disclosed or used without authorization or collected? and that is through the use of safeguards. And currently there is no requirement in LA FOIP that says a local authority needs to have safeguards. However, how else would you protect the information? That being said, there's currently a Bill 31 being considered in front of the Legislative Assembly, and if passed, it will require that a local authority establish policies and procedures to maintain administrative, technical, and physical safeguards that will protect the information, protect against anticipated threat or loss of the information, and ensure compliance by its employees. There are three main types of safeguards. The first is administrative safeguards. So that would be written policies and procedures about the personal information. So, for example, maybe one policy is that only the administrator has access to the file cabinet where personal information is kept. Next, there are technical safeguards. So, for example, that would be passwords on computers that contain personal information. And finally, physical safeguards. So making sure that file cabinet is locked at the end of every day and making sure personal information isn't in someone's basement being stored for long term. We've heard that before. So next I'll talk about what to do in the event of a privacy breach. So first, it's to recognize what is a privacy breach. It can be over-collection of personal information, an unauthorized use of personal information, an unauthorized disclosure of personal information, or using or disclosing inaccurate personal information. The first thing to do is contain the breach. That means make sure it doesn't continue to keep going. So stop the unauthorized practice, recover records, shut down a system that has been causing the breach, revoking access to personal information, or correcting weaknesses in physical security. Next, it's notification. So if you're a large organization, you might want to contact the privacy officer. You might proactively report the breach to our office. We can help you through the steps of dealing with the breach. If maybe you suspect a burglary, you might contact police. And finally, you will want to, in most cases, contact the affected individuals, but this might happen a bit later after the next step, which is investigating the breach. On the screen now, you'll see lots of questions that will guide you through your investigations, and there might also be more questions and resources on our website that we'll talk about later. However, the main thing of this step is to recognize what was the root cause of the breach. And the most important thing is to prevent future breaches. So what steps can be taken to prevent a similar breach? Do you have to change your policies or procedures or make some? Are there additional safeguards that are needed? Are there training that is needed? And should a practice like collecting personal information be stopped? Finally, you want to make a privacy breach report. This can be sent to our office just for a final check to make sure you've handled it appropriately. Also, it's good to keep it as a record in case there are recurring breaches that happen. You can maybe make modifications to prevent future breaches.
Okay, so some of you might be wondering who we are. The Information and Privacy Commissioner is an independent officer of the Saskatchewan Legislative Assembly, and the IPC has jurisdiction over 3 statutes: the Freedom of Information and Protection of Privacy Act, which is FOIP, the Local Authority Freedom of Information and Protection of Privacy Act, LA FOIP, and the Health Information Protection Act, HIPAA. So one of the bigger processes that we have in our office is a review process. And what a review is if a request for review is received, an early resolution officer, ERO, from our office will be in contact with you to discuss the review. This is when an individual is dissatisfied with how the local authority has responded to their access request, and that is how the review is started. When you get a call from us, don't panic. We're really nice to deal with, and the ERO will attempt to come to an early resolution before a formal review is opened. If early resolution is unsuccessful, then the file will be assigned to an analyst. Once a review file is opened, the local authority will be given 2 weeks to make a submission and provide it to an analyst. Though usually our analysts are fairly forgiving, so we can make exceptions if need be. Resources on how to write a submission can be found on our website, along with other resources such as the Guide to Exemptions. Once the submission is received, the analyst will commence the analysis of the records and the submission. Generally, during this time, the analyst will not contact you unless they have further questions. Once we're done with the analysis, we will provide you with a draft review report. And this is a time when you can come back to us with any factual errors that we may have. This is also a good time to come to an informal resolution with review files, such as you can release additional records or revise a fee estimate, etc. Following any commentary or changes, the Commissioner will finalize the report, and once the report is complete, the local authority has 30 days to respond to any recommendations. No response is considered non-compliance, and once the review is complete, we generally give about 3 days before we post the report to our website and make it public. In some circumstances, we may post it right away, but that is at the Commissioner's discretion and has only happened once or twice. And on the screen are just some examples of what we do reviews on, such as someone coming to our office saying that they received a response saying that the records they requested do not exist or they cannot be found. And during a review like this, we would just ask the local authority to demonstrate its search efforts in looking for this request. Some applicants make complaints that they have not received a response at all. And in that case, we may not even need to go to a review. We may just end up calling you guys up and asking kind of what's going on and seeing if we can assist at all to help you to complete the request. Another big part of what we do is privacy breach investigations, such as what Mel was talking about. And we can learn of a privacy breach in various ways, such as proactively reporting, which is when you as a local authority come to us with a breach that has occurred. Or we can get a citizen complaint or a third-party notification, which is generally when, say, someone receives a fax in error about another individual. They can contact us and let us know that this has happened. Generally, we will either contact you to let you know that this has happened, or we'll instruct that third party to contact you to let you know as well. Employees of a local authority can inform us of inappropriate practices within the organization itself. And in very rare cases, some individuals will skip us altogether and just go straight to the media, though that has not happened in a very long time. So the investigation process is very similar to the review process. It's just a little different in a sense that EROs will more so be there to make sure that all necessary information is received and to send out notification that we will be opening a file. Early resolution is not as easy to come by in a breach file, though it can happen. Just like a review, the analyst will ensure an investigation report is received in 2 weeks, and we will review materials received and determine the direction of the investigation. And what I mean when I say that is that in a case of a proactively reported breach, sometimes we will get a local authority's internal investigation report and we'll go through it and we won't have any recommendations. We'll agree with how the public body went through the investigation and say, good job, we're closing the file. If we do get the internal investigation report and we're not satisfied with the steps taken, then we'll go forward with our own formal investigation. And similar to the review, the analyst will provide you with a draft report, and then when that is finished, the commissioner will finalize the report, and the local authority and any complainants will receive a copy of the final report. And just like a review, you have 30 days to respond to any recommendations made. A non-response is considered non-compliance. And just a little bit more on proactively reported breaches and informal resolutions. Where possible, we will aim to achieve informal resolutions for investigation files, and this can be done in various ways, such as dispelling any misunderstandings or clarify objectives between the local authority and the complainant, or facilitate negotiations between the local authority and the complainant by clarifying the role of the IPC and identifying any possible outcomes of an investigation. In cases such as this, we may have a complainant come to us who wants some sort of financial compensation out of a breach, or they will want to have someone be fired. And this is not something that we can do. So sometimes us just explaining that will make the complainant maybe not want to go forward with a complaint. And like I had said before, if we're satisfied with an internal investigation report, we can also close a file informally at that time.
Hello, this is Stephen. I'm a policy and legal advisor with the Saskatchewan Urban Municipalities Association, also known as SUMA, and I just wanted to thank the office for having me here today. Of course, as you might know, SUMA is an organization that represents 440 cities, towns, villages, resort villages, and northern communities, and we really value our relationship with the Office of the Information and Privacy Commissioner. And so I leapt at the opportunity to be able to come here and speak about balancing the requirements in municipal legislation along with FOIP, I think, or FOIP. It might be easier than you think to do both because in a lot of places, although it might seem that things are daunting and conflicting, quite often they actually work quite well together. But it's just a matter of trying to get your head around some of these concepts once in a while. I also must say that I encourage you to work with the office. They are an independent officer of the legislature. They're not an advocate for complainants or anything like that. They just hear the concerns and they work to resolve issues. And so I think that that's something that should be really highlighted, underlined, because they are a resource. And of course, you know, for urban municipalities that are out there, I will also seek to help you the best as I can in my meager ways. But at the outset, I just want to say that sometimes where the conflict comes is why I have balancing the private and the public up there, or perhaps also could be said as balancing the public and private as I have written it out there. When you're looking at LA FOIP and you're looking at municipal legislation, for a lot of things you need to be out there. You need to be public with things that go on at council. However, there's also a duty to keep things private, and it can be confusing at times. And what I've done in this presentation is kind of separate a bit of some of these conceptions, and I also will have a bit of tips for this and that might be able to assist. A general rule of thumb might be, while not ironclad, but chances are if a councillor is doing something, that the councillor has a very public role. They are the interface for the municipal government and also the residents. Administrators quite often are dealing with private information, and so it's important to have those sorts of them protecting that information, and both sides to respect what the other is trying to do. So just to go into some of that confusing kind of balance, you start off with the duty to have public meetings. Now, everybody will know that council meetings must be public, and it's important to have decisions made in public, because the acts are not effective. Any resolution or bylaw is not effective unless you are doing it in public. So the times that you can go in camera or close meetings is actually pretty limited. And those are a lot of those things were touched on when in discussing LA FOIP. And at the same time, too, there's also a longer range and strategic planning exemption. And also appeals committees can make decisions in a closed meetings. Of course, you'll quite often be dealing with an individual, and so you'll understand why that should be kept private. Now, you'll notice there's a lot of acronyms up there, and I'm going to just touch on that right now. Of course, the MA is Municipalities Act. That deals, of course, with towns, villages, and resort villages, as well as rural municipalities. The MR is Municipalities Regulations. So the Municipal Act and Municipalities Act regulations, of course, work together. You also have Cities Act, which is CA, and Cities Regulations, which is CR. Then NMA is the Northern Municipalities Act 2010, and that's for northern municipalities. The general rule of thumb is all those north of the tree line in the northern Saskatchewan, as well as the Northern Municipalities Regulations. So you have all these acts, and that's another aspect which can make this pretty confusing, because, well, you know, how these interact? Well, thankfully enough, or perhaps confusingly enough, depending how you're looking at it, a lot of the sections are very similar. There's certain powers that a city has that aren't extended to others. There's also certain responsibilities as well for cities that aren't extended to others. But on a lot of the big issues, like for instance, keeping council meetings public, it's pretty much exactly, not only similar wording, but exactly the same wording for each municipal government. So not only am I going to be talking a little bit here, as I already have, about municipal legislation. When I use the word municipal legislation, I'm referring to Municipalities Act, Cities Act, and Northern Municipalities Act 2010 in kind of shorthand, without having to refer to each one of those acts again and again. So municipal legislation interacting with LA FOIP, but then also keeping in mind that there's other legislation that's out there that carries duties, because why would anything easy would be just not worth doing. So on top of that, of course, there's case law, and that also has its own unique interaction with this. And I'll be taking a brief detour to kind of highlight that. So I think that if anything else, one of the tips I would give for council members as they're out there having public meetings and making decisions in public, it's very important to be very careful collecting or accessing information at any time. You don't want to all of a sudden have something come up in public meeting which is something that should be private, and that you may have come across in an in-camera meeting and should not be shared. That being said as well, be very careful and respectful whenever you're taking notes. That could also, you know, be one of those situations where something could become public, or become something that you might have to carry to later be subject to a request. And so I'm not saying so much, you know, never take notes or never do anything. Just be mindful of what you're doing. On top of that, email. Keep in mind what you're doing for a business. That can get pretty messy pretty quickly, as well as also using electronic instruments that are out there. Of course, you know, iPads, computers, things like that. How are you storing this information? And if you're working on things, you want to make sure that information that should probably be public can easily be made public. Some of these duties as well are very new, and this next slide here on council duties highlights some of these new duties that have been created. Now, a key one is the public disclosure statements, which must be, of course, hence their name, public. That, of course, is the statement which summarizes the various things that might give rise to a financial or pecuniary interest in any matter before council. There's also an interesting clause in the municipal legislation about keeping confidential matters private until they're discussed at a public meeting. That's an important one. There was a matter that came up a couple of years ago in Saskatoon about keeping confidential matters private, that there was some discussion and controversy over with a former council member. It's some of these things can, once in a while you may want to get advice from certain people, but if it's a confidential thing, well, then you have to keep it confidential. You can't share it with anybody outside of the municipality. And so it's an important thing to do. Of course, too, well, why don't I just make it public by saying it during a public meeting? Well, no, that's not really how this works either. That's not a useful workaround. And in fact, the Code of Ethics slams the door shut on that one quite well. Not only is there a duty, of course, to conduct yourself transparently and accountably, to be out there, to show rationale for your decisions and be fair with your decisions, but also keep matters confidential. And that's an important duty that I'll get into a little bit, a specific indication of that a little bit later. But I first just want to say, even though these are mostly new duties most of these are new things, like for instance with the Code of Ethics, that's only arisen in October with the new amendments to municipal legislation. That being said, all council members swore that they were very well aware of these obligations when they swore their oath of office. And one of the things that are in there is that I've known and I know and understand and I've read the Code of Ethics and the municipal legislation and conflict of interest things. And so it's important to keep in mind. I thought it was very interesting, as an aside, that in the Barclay report, when Commissioner Ronald Barclay looked at the situation that arose in the RM of Sherwood, that he also looked at the oath of office in that, and actually that gave him guidance in how he was how he approached the issue, and also whether the reeve in question was following his duties. And so it could potentially be something that courts and judges consider, and it's something to definitely keep in mind. Just to go to LA FOIP for one last moment here, Section 56 touches on the duty of every person who says this, duties particularly for councillors and in those in municipal governance, that every person who knowingly collects, uses, or discloses personal information is guilty of an offense and can receive a $1,000 fine or 3 months imprisonment. And so that's collecting these things inappropriately. And there's a recent decision out of the British Columbia Court of Appeal called Skaken, which kind of gives an example of this. A fellow decided that this one report that he received while he was on council, this councillor decided that this report that he received, he felt that people should know about it, that he was kind of being a whistleblower, so to speak. Well, the courts took a dim view of it. His acts, in fact, involved him disclosing the confidential report to a CBC reporter, and the courts, upon hearing all the evidence, found that he was in fact contravening the act, their own version of LA FOIP. And so, not only is that a lot of court costs and embarrassment, but it's also a offense which carried sanctions with it. So just to kind of show how this interacts with common law or court decisions, that's essentially what common law is. There's the gaps of legislation, so to speak, in which people don't know, okay, what does this word really mean? Even though we've defined it, what does it mean in practice? Well, they go to court. The court then decides, well, this is what that means. And then in time, sometimes it's reviewed again and put more, even defined further or understood or amended as time goes on. So this common law has created this one principle of bad faith. And this ties to public accountability and transparency specifically. The Duffield decision particularly refers to evidence that shows that decisions were made without candor. That essentially means secretive decisions, decisions that are not understood or made in that public realm. And so this is one of those things of ensuring that you're being open for council members. And again, that oath of office is another guide on this, because it talks about impartially and fairly carrying out your duties. And specifically, that kind of ties to bad faith. The decision of Shell Lake shows that when this doesn't necessarily arrive, in that case, the village council passed a resolution during a special meeting that allowed some building purchasers to apply for a permit, a liquor permit. and to change it, essentially the building, into a tavern. And I guess Shell Lake felt that that was a pretty controversial decision. They made a decision in a proper form. However, they decided not to talk about it on Coffee Row, that great area of sober second thought and decision review. There is nothing wrong with not deciding to broadcast decisions in that sort of fashion, and that's what was found in that case. There was no duty to shout it from the rooftops. That being said, of course, you still have to have proper minutes and proper things put forward and decisions made in a proper public forum. So another interesting decision that I don't have up there, but I just wanted to touch on, is a Hughes and Eston decision from 2008, Saskatchewan Court of Queen's Bench. In Eston, they had a short walkabout meeting, and they were visiting various properties to take a look at them with respect to nuisance properties. And they just happened to meet up with this one person who they had a matter up at the next regularly scheduled council meeting. Yes, there should be, for all the council members who are on this call or at this meeting, you should be having alarm bells in the back of your mind, because yes, that's a risky time to say the least. But however, this was a walkabout meeting that actually was, this was actually properly notified as it was going to be occurring. So it was proper notification was in the town office and carried out, and so it was a proper meeting. And they actually were found not to have discussed this, pretty much just, oh, hello, goodbye, and that was it. I get it once in a while. When is a meeting not a meeting? Well, it's probably always a meeting, so be very careful. To shift it over to administrative duties, this is just to touch base on CAOs, or chief administrative officers, or administrators. I just might refer to that as administration or administrator. That's essentially what I'm talking about. Of course, there's the Tax Enforcement Act, and that requires certain things be made public. Of course, that's lists of lands in arrears, and that ties to the advertisements that must be made. I think that all administrators will be quite well aware of these sorts of duties, and so I'm not going to dwell on that in any sort of great depth, but I thought it was just important to at least have it out there and then understand there's certain things that you'd have to have out there. That being said, you'll also note, though, there's nothing tying it to personal information, and that somebody is personally identified. The next is, and again, this kind of relates to LA FOIP, is the duties of administration in keeping documents and books and records. Now, as you'll know, administrator will, in the usual course of things, be in charge of all this. And you'll also have noted, quite rightly, that earlier in this presentation, that Kayla and Melanie were talking about how head means in LA FOIP, mayor. And so, yes, so quite often, the mayor suddenly will find himself with the duties that perhaps he didn't recognize at first, because, yes, usually the duty falls to the administrator in the usual course of business. But that being said, there can be a designated individual under the Act, and so you might want to make sure that you get that in writing if you would like it to be that way, and appoint that person you'd want to have appointed, such as your administrator. And because, as you'll see here, the administrator actually has the duty to keep these things under lock and key, or however the case might be, determining on what the nature of these sort of documents are. And it's important to keep that in mind. And yes, and so not to belabor too much, because I think that a lot of these things will be pretty clear to a lot of the administrators who are taking part on this, but just to keep that in mind. Also, there is the public right to inspect, and this, of course, also ties to LA FOIP's things that should be kept public as well. And, it was mentioned about having safeguards in place, and just in case your municipality has not done it yet, and if you have, and it's just been a while, either create that policy or process, get it in place, so there's clear understanding of who's responsible for what in the usual case and usual situations, and also in, hopefully never happens to you, touch wood, a breach situation, so you can have immediate response and work with any timelines, or of course any request. You'll see here that with the public right to inspect here, these various documents, when you look at it, you'll see that there's also the talks about how you must furnish copies in a reasonable time and charge a fee approved by council. Well, you can probably have a policy in place that covers everything here, as well as any duties you'd have under LA FOIP, and ensure that everything is working together very well. And finally, there's a couple of other documents that there's also a public right to inspect. There's the Employee Code of Conduct, and that is also a new duty that has been created with the recent municipal conflict of interest amendments. And it's to be out there ensuring that people know that what the code of conduct is for employees, that residents know what municipal employees are supposed to be doing. There's also, of course, the assessment role that's to be made public. That's a time-limited obligation, just mostly tied to appeals of assessments. The waterworks information, if you've never seen that before, there's actually very extensive amounts of information that must be made public, and to ensure that please ensure that you do make that public. And of course, touching on cities, they have special obligations as well, and that's set out in the city's regulations. With that, that's my last slide, and just before I hand this back over to the good folks here, I just want to ensure that I made one more mention that just to encourage you to work with the Office of Information and Privacy Commissioner and Urban Municipalities. Feel free to give me a call as well if you have questions. Be preemptive on issues. Get policies in place, be careful with what information you're collecting, and be sure that there's reasons for what you're doing, and just generally anything that you're working on. It's important to understand why you're doing things and not just do them where there could be certain risks. I also just wanted to say as well, if you're kind of stuck and don't quite understand, some mention's been made of the great resources that are on the office's website, and one last time I will say, Urban Municipalities, feel free to give me a call. Thank you very much.
Thanks, Steve, for helping us with this today. So our last issue is resources and where you can go for help. On our website, we have many resources that can help you out. So the main one is the IPC Guide to Exemptions, which talk about all the exemptions and how we apply them, as well as other things such as fees and possession and control. We have a best practice document for responding to access requests. We have a document of what to expect from us if there is a review of privacy breach guidelines for government institutions and local authorities. We'll run through everything I explained if there is a privacy breach. And the last two documents are more for counselors, and they touch on LA FOIP, but they also touch on the difference between the local authorities documents and documents that might be only of the counselor, such as political documents. So you can give those a look at. Hopefully soon we will be launching our new website, and it will be even easier to find what you're looking for. The Ministry of Justice has an access and privacy branch that also has a lot of resources, such as online training, flow charts, Section 7 response templates, so you can contact them for more information about what they have to offer. Like Steve said, you can call him at SUMA, and also you can call us at any time. We can give you confidential advice, and if you're in the midst of a review or investigation, we can help guide you through the process.
Okay, so on the screen is our contact information should you need to get a hold of us, as well as our email address, the webmaster@oipc.sk.ca, and feel free to follow us on Twitter at Sask IPC. We're always tweeting about our new reports and blogs and resources and etc., etc. Thank you for joining us.